introduce our esteemed speakers. First, we have Mr. Samir Rastogi, Managing Partner at India Juris with more than 20 years of experience in advising clients globally in various sectors like private equity and venture capital and many more. I welcome Mr. Samir Rastogi.
Thank you. Thank you.
And we have Mr. Shivram sir, Associate Partner. And we have Mr. Shivram sir, Associate Partner at India Juris, providing legal advice and representation to clients from various countries and sectors. I welcome Mr. Shivram sir.
Thank you.
Now, I welcome Mr. Samir Rastogi to take this webinar forward.
We are again very delighted to discuss developments in GIFT City. And since the GIFT City has been active since April 2022, when we have found first AIF regulations released by the regulator over there, we have been conducting these webinars for the purposes of creating awareness and disseminating information about the GIFT City, India's one and only international financial center. So today we are going to deliberate upon a very new released regulations, which are listing regulations, which are released on 30th August 2024. So it's not even a month. These listing regulations have been released by the regulator. And today we are trying to give concept-wise broad information, because if we go the detail, the whole regulation would take a lot of time to touch upon each and every point. So today I'm trying to give a broad informational concept-wise content of these regulations, that what are these regulations all about, what it covers, and how we can go about it, so that the participants who are here, they may know whenever they have any, whether they are the consultants or funds or advisors, that how they can benefit from these regulations. And if you really want to know further deep dive detailed information about these regulations, you'll find all these regulations on the website of IFSCA. So let me share, we have made a small presentation. It's not really small, it's a little big. So I'll try to make it easy and share as simple way as I can. And we go into these regulations and thereafter. So since it's too new, we don't have at the moment use cases or practical aspects of it, as we give a lot of information about the practical aspects of operating funds in GIFT City. So since it's not even a month, these regulations are released. So maybe in our next webinars, because some assignments are underway, maybe next webinar or thereafter, we would be happy to share practical aspects of listings and regulations which are released by the regulator. So let me share my presentation to go forward. So I hope my presentation is visible to all. So friends, we are today trying to understand the IFSCA listing regulation, those who are new to GIFT City. So IFSCA stands for International Financial Service Center Authority. It is equivalent to SEBI in India. It is the regulator equivalent to SEBI in India, and this regulator regulates all listings, funds operating in GIFT City. So like you have in India, you have SEBI regulations, there you have IFSCA regulations. So today we are going to look at the listing regulations which are released. So in these listing regulations, so I have just put the main contents, like we will have a small introduction, the objective, important concepts and definitions. applicability of listing regulations, general conditions, listing of specified securities, listing of aspects, listing of depository receipts, listing of debt securities, disclosure in offer document, process of listing, and post issue report. So there are many other things also in the regulation, but this I have taken just to give a broad overview. And whatever words you are looking at in the content page, whether it is specified security or aspects or depository receipts, what meaning they have been given in these regulations will go on that, some important ones, and then we proceed forward. So friends, you may know that sometime back in January, the government of India has notified a listing scheme which provided framework for direct listing of equity shares of Indian public company on international exchanges. So that was the start. And in February, standing committee gave recommendations that IFSCA on policy and regulatory matters for the development of primary market in GIFT IFSC. So GIFT is Gujarat International Financial Technology. It's like Tech City. So we call it GIFT City. And recommended listing of companies should be aligned with international financial service centers such as Singapore, Hong Kong, USA, UK, and replace IFSC issuance and listing of security regulations 2020. So now the GIFT City government of India is benchmarking this with benchmarking this with global financial centers, so that India is equivalent to any other global financial hub where we find ease of listing and accessing market, global markets, global public. So keeping in view that on 30th August 2024, this IFSCA issued this listing regulations. So what is the objective of this regulation? So it provides regulatory framework for IPO and FPO. So what is FPO? We'll see. All of you must be who are in the capital market space, they would be knowing it. So IPO and FPO of specified securities, follow-on public offer FPO. Specified, what is specified securities? We'll just see. Debt securities, depositories, receipts, and other permitted financial products like commercial papers, certificate of deposit, etc., on recognized stock exchanges in IFSC. So this provides the whole regulatory framework for listing of all these financial instruments which I just written on where to list on recognized stock exchange in IFSC. And what is recognized stock exchanges? So at the moment we have two exchanges in IFSC. One is of BSE, which is India, which is India Annex of BSE, and the other one is for NSE, International Exchange, NSE. So these two are operating there, and to these two exchanges we are referring as recognized stock exchanges at the moment in these regulations. So IFSCA listing regulation enable company incorporated in India, in IFSC, and foreign jurisdictions. So now you see the company in India, in IFSC and foreign jurisdiction can get listed their securities over there, but not all foreign jurisdiction. The foreign jurisdiction which is FATF compliant, Financial Action Task Force. Most of you may be knowing 39 countries are party to this FATF. India is one of them, including US, China. So all these countries, so the countries which are, if your client or you yourself are in FATF compliant jurisdiction, any foreign jurisdiction, then you can have an opportunity to take benefit of Indian IFSCA capital markets through GIFT City. So friends, these are the main definitions. I had tried to put it in more simple manner, which are under the regulations. So while we go through this presentation, these terms will come. That's why I have put it in that series. So SPAC, most of you would be knowing that SPAC is very well known in US markets, where large special purpose acquisition vehicle, they are made, they are heavily funded by private equity investors. They are specifically made to acquire certain business, certain company, or certain assets, and then they are listed, traded, and there's a whole thing goes, and there's very huge valuations and huge money involved in SPACs. So special purpose vehicle, it refers to a company with no active business operations and which is created itself to give effect of a to give effect to business combination. And what is business combination? It refers to a merger, amalgamation, or acquisition of shares. As I just said, what SPAC does, it acquires businesses, assets, companies for which purpose it is made. Certificate of deposit, it refers to negotiable unsecured financial instrument used in money market, issued either in electronic form or as usance promissory note. It is based on funds deposited at bank and has maturity period of up to 1 year. So these kind of security deposits which are issued, they can also be listed. Commercial papers, most of you must be knowing CP notes. So commercial unsecured money market instrument issued in the form of promissory notes. So they can also be listed. Debt securities, NCDs are there, non-convertible debt instruments. They can be listed. Specified securities means equity share and convertible. Any company having equity share or a convertible security, those can be listed. So depository receipts, you can list depository receipt, means a negotiable financial instrument representing underlying securities of an issuer in another jurisdiction. Superior right equity shares or SR equity shares means such class of equity shares of an issuer means any company who is issuing the shares, which grants their holder voting rights superior to the ordinary equity shares. So when we do a lot of transactions, certain shareholders have different better rights, different rights. So those kind of superior right equity shares, it is referring to as SR equity shares. Secondary listing. So there is a thing called secondary listing also. What is this? An issuer having its specified securities listed. Now specified security we just saw equity or a convertible security. So any company which is already having its specified security listed in foreign jurisdiction. So it may also list those specified securities on a recognized stock exchange at the moment, which is BSE, India INX BSE and International NSE, with or without making public offer. So they can do that in IFSC. So if you are a foreign company or an investment manager, if you have assets, if you have companies listed anywhere in the world in a FATF compliant jurisdiction, and even if you wish to access market through Indian GIFT City, then you are happy to, you should explore secondary listing of your securities here at this exchange as well. So follow on public offer FPO or OFS, which is further public offer, means an offer of a specified security by listed entity to the public for subscription and include an offer for sale of specified securities to the public by any existing holder of such specified security in a listed issuer. Now the whole catch point over here is means any offer of specified securities by a listed entity. So here the listed entity means the entity which is listed in IFSC. It is not listed in India. So the word over here listed entity, the entities which are listed in IFSC, they can do FPO and OFS and further. So you can see the definition of listed entity below this. Means an entity whose specified securities or debt securities or depository receipts or any other permitted financial products are listed on a recognized exchange, which is the two which I have just mentioned. So we saw that what is the scope of these regulations. Now we see applicability, to whom it applies. So these regulations shall apply to an IPO of a specified security by an unlisted entity. Means if some specified security means equity or convertibles, उसका अगर IPO लेके आ रहे हैं, an FP of a specified security by a listed entity means follow on offer or further offer of an entity which is already listed in IFSC exchanges. An IPO of a specified security by SPAC. So you can see these regulations cover all these things. An IPO of security listed by SPAC, right issue or a preferential issue or a qualified institutional placement of a specified security by a listed entity. It means listed in IFSC. Issuing and listing of depository receipts by an entity. Issuing and listing of debt securities, secondary listing of securities, listing of commercial papers, certificate deposits or other financial products as permitted by the authority. So now you can see the application of these regulations. What is the vast, framework has been made to enable so many financial products to be listed at IFSC exchanges. So these are the general conditions. The issuer is incorporated or set up either in IFSC or India or in foreign jurisdiction. So who is eligible to list? It's an IF of FATF. When we say foreign jurisdiction, it goes without saying that it has to be FATF compliant jurisdiction. In FATF, if you see, there is a gray list also. So if their country is coming from the gray list, probably they would have a challenge to, list the securities here in IFSC. The issuer operates in conformity with its constitution and it is eligible to issue the whatever financial products they are trying to list here in conformity with the relevant laws of its home jurisdiction. And now in case of Indian company, now in case where Indian public company is proposing to list its equity shares, then it has to meet requirement of Schedule 11 of the FEMA Foreign Exchange Management Non-Debt Rules Instruments 2019 and companies listing of equity shares in permissible jurisdiction rule 2024. So this is in case of an Indian company which is already listed, though they have to comply with these regulations as well. So some people ask whether we need to keep in DMAT. Yes, you are required to keep the securities in the DMAT. What should be the currency of it would be a foreign currency. It would not be an INR denominated listing. It has to be a specified foreign currency listing. So that is one thing to be noted. So now these were the general. Now we'll go with each and every, like we said, for listing of specified securities. Then we look something about listing of debt securities, listing of deposit receipts, and all those things we'll see one by one. And then we see the process of listing. So listing of specified securities, whether it is an IPO or offer for sale or further follow-on offer, it applies to both. Listing of specified securities, again I repeat that specified security means equity share or convertible security, both. So if any company, whether it's registered in India or outside India or in IFSCA, if they want to list their specified securities in exchange in GIFT City, then this is the eligibility criteria for FPO. The operating revenue at least USD 20 million in last financial year or average over last 3 financial years. So these are the, now you can see If you are a company who is looking to list in IFSC, then you have to see these revenue levels have to be there. These are the requirement to make you eligible to list in IFSC. So operating revenue should be at least 20 million in last 3 years. Pre-tax profit at least $1 million in last financial year or averaged over the last 3 financial years. Post-issue market capitalization has to be $25 million. So if you are coming with IPO for SR equity shares, which was special rights, the shares which are having some special rights over ordinary equity shares, then an issuer with SR equity shares can conduct an IPO of its ordinary shares if resolution is passed by GM. SR equity shares have been held at least 3 months before the listing. So friends, here the objective is not to bother you with so many things. The objective is one should have an idea that these kind of regulations are existing. Whenever you think of listing, at least you would have in mind, okay, there is some regulation or requirements on eligibility on the revenue side, then you can go and check again with the regulations. So eligibility criteria for OFS, offer for sale. So now the security must be held by existing shareholder for at least 1 year before filing the draft offer document. अब draft offer document किसके पास फाइल करना है? IFSCA. Like here we have SEBI, there we have IFSCA. The holding period for equity shares obtained even if there is a convertible equities, if it is after conversion, then also the time year will be 1 year will be calculated after conversion. The conversion must be completed before the filing the draft offer document with full disclosure provided in the document. So it means if the company is having any convertible, that whatever conversion has to be done, it has to be done before you file offer document with IFSC. There are certain exceptions to eligibility criteria for offer for sale. The shares were acquired through a merger or so these are out of if they are issued as a bonus or security held for 1 year, issued from free reserves and share premium as of the end of the financial year, not issued by utilization of revaluation reserves or unrealized. So there are certain exceptions. So whenever you are going for this, you can revisit these guidelines and look at these exceptions where it applies to you. So still friends, we are going with the listing of specified securities. So filing of offer document, if the issue size exceeds $50 million, the company shall file offer document along with due diligence certificate with IFSCA. So if your offer size is above 50 million, then you file a due diligence certificate with the regulator for seeking observation. So if your offer size is less than 50 million, then you have the relaxation on this. Pricing, the company or the issuer shall determine the pricing in consultation with the lead manager. And now who is the lead manager? Lead managers are the investment banker, again registered with the authority. So now you have to see whenever you are dealing with various stakeholders, it will be registered with the authority. So Gift City, it's a full financial ecosystem. You have a investment manager, you have trustee, you have debenture trustees, you have fund account. All financial ecosystem is available in Gift City, and you will find very proactive professionals there. So issuer shall determine the pricing in consultation with lead manager through fixed price or book building mechanism. Indian company shall also comply with the requirement provided in FEMA and non-debt rules, because FEMA and non-debt rules will come. They have to comply every time because that is the requirement, because they are from India, so they have to comply RBI regulation. So what is the offer timing? It shall be made within 12 months. The offer shall be made within a 12 months for issue greater than 50 million. When the issue size is greater than 50 million, then 12 months from issuance of observation by IFSCA. Means you send your offer document to them and they issue your observation, then you can, from there within 12 months you can make the offer. But if your size is less than 50 million, then the moment offer document is received by the regulatory authority, you can proceed with it. So it's that way. So below 50 million, the environment is quite relaxed and easy. I mean, above that also it's not that cumbersome. It's just some more protection is there. But below 50 million, it's quite easy. So what is the offer period? Shall be open for 1 to 10 working days. Minimum public offer and shareholding. Indian, including an IFSC, comply with provisions. SCRA, they have to comply. And foreign company, the minimum offer and allotment shall be at least 10% of the post-issue capital. So you have anchor investor, underwriter, allotment, because the this PowerPoint is too long. So I will just go a little fast and will circulate this. You can see at your ease as well. So you need if issuer may offer a portion of issue size to an anchor investors by providing relevant disclosures. So you can have anchor investor also. Underwriter arrangement must be disclosed in the offer document. For allotment, investors will be allotted shares on proportionate or discretionary basis. Now you see discretionary basis is also there. So you have green show option, you have provision for monitoring agency and for lockup. So green show option, if you want to issue further shares for market stabilization, you can do that. You may choose to, this is a monitoring agency is optional. You may choose to appoint any credit rating agency registered with authority. There is a lockup. Now the point is lockup. Pre-issue shareholding of promoters and controlling shareholders, it will lock for 180 days from the allotment in the IPO. And shareholding of the SR equity shares will be locked off after IPO until the later of their conversion to ordinary shares 1 year from the date of allotment of IPO. So these are the things there. So now at the moment, friends, you have to hear that there is a lockup for the promoters of 180 days and others. Details you can see when you are facing the real situations. So this we were looking at the listing of specified securities, which is equity and convertible. So now we are looking at some of the highlights of the listing of SPAC, which is Special Purpose Acquisition Company. So what is the eligibility? The target business combination is not identified before IPO. It includes provision for redemption and liquidation as per regulation. The sponsor has a strong track record in SPAC transactions. So the sponsor has a strong track record in its objective. Offer timing within 12 months from the observation by the authority. And issue size minimum of USD 50 million, because SPAC generally, if you see US, the SPAC size of the transaction of SPACs are very, very high. So 50 million from international perspective is on a very conservative side. So pre-IPO sponsor must have an aggregate subscription of at least USD 10 million or at least 2.5 of the issue size. Post-IPO sponsor must hold between 15 to 20% post-issue capital. So this is in case of an SPAC, these are the things related to issue size. Pricing, fixed pricing mechanism has to be. Offer period 1 to 10 working days as we saw for specified securities. Application size, minimum application size has to be of $1 lakh, $100,000. What are the specific SPAC obligations? The SPAC to keep all IPO proceeds in an interest-bearing escrow account managed by an independent custodian. You have custodian in Gift City, so you can, when you do all these things, you will have them. These proceeds can only be invested in short-term investment grade liquid instruments. SPAC may withdraw interest and other income from the proceed solely for payment of taxes and general working capital expenses. SPAC must seek shareholder approval for proposed business combination. Means, as you saw that this SPAC, when it is going to acquire or merge whatever business it is going to take, that should not have been identified before you are taking the money. So once after you are going to the market, once you are identifying, selecting it, it requires proposed business combination must seek shareholders approval. Prior approval of majority shareholder is required for business combination. So shareholders who vote against proposal have the right to redeem their shares. In the event of change in control, SPAC must also offer redemption option to shareholders. So these are the standard things when SPAC is coming. And I personally see a lot of things happening from the US investors and global investors may use these platform. Post business combination entity shall immediately disclose details regarding completed transactions. An entity is required to meet listing eligibility criteria and shall comply with listing. So there is lockup in SPAC as well. The share of sponsor shall be locked up for a period of 1 year from the date of closing of the business combination. So there is appropriate steps have been taken by the regulator. So that was a small about SPAC. So we see listing of depository receipts. So friend, I am giving you a very broad perspective that these are the things on specified securities, on SPACs, on SPAC, on depository receipt, so that you have a fairly idea what is there. So when you are going to list a depository receipt, then what is the eligibility? Authorized to issue depository receipt according to the laws of its home jurisdiction. The underlying security represented by such depository receipt is in demat form, fully paid and free from all. Those depository receipts which are going to get listed, they should have this thing. Offer size, the offer size shall not be less than $700,000. Fixed pricing mechanism is there and offer period is 1 to 10. This offer period is standard across all kind of listings. So minimum subscription is $700,000. Secondary listing without public offer, an issuer whose security is listed outside IFSCA may list its depository receipt by filing listing appeal. So who are already listed outside India, outside IFSCA, they can also get listed by filing application with the regulator. So this was about depository receipt. The regulations have very detailed information about this, but I am capturing here very broad, from the broad perspective. So in debt securities, we have the regulation also provide ESG debt securities. So applicability with respect to ESG debt securities. So applicable on environmental, social, because if you see today, now there is a lot of awareness and emphasis on ESG. The financial institution, the banks which are doing lending, they are also happy to give preferable rate to the companies who are ESG compliant or who are following ESG. So coming back to this, applicable on environmental, social and governance. Labeled debt securities including green, social sustainability linked debt securities or any other ESG labeled debt securities. So you have to make additional disclosure requirement for ESG labeled debt securities other than sustainability linked debt security. So further detail you will find in the regulations. Please take a look if you want to further deep dive. A statement on ESG objective. These are the additional disclosure which you have to make when you want to list a debt securities related to ESG. Details of process followed by the issuer for evaluating and selecting the project. Proposed use of proceeds and detail of system and procedure to be employed for tracking the deployment of proceeds of the issue. Because deployment is very essential. If you deploy the proceeds in a non-ESG or non-sustainability, then it will be an issue. Additional disclosure requirement for sustainability linked debt securities. Issuer shall disclose rationale for issuance of sustainability linked debt securities and consistency with issuer. So now the issuer shall adhere to pre-issuance and post-issuance obligation in accordance with relevant international. So these are certain things about if the now here the thing to remember is that the regulation provide listing of debt securities relating to ESG and sustainability, and they have certain disclosures to be made. And when you are entering into such transaction, then you can have further details on these regulations. So filing of document. So now these are general, any kind of debt security. When you are those first three which we saw, they were the debt securities list related to ESG. But these provisions here on are applying to all kind of debt securities which are getting listed in IFSCA. So filing of document. So the issuer must file the application along with copy of offer document on information memorandum with recognized stock exchange. Credit rating is mandatory and shall disclose detailed rating in offer document. From April 1, 2025, the issuer shall obtain a credit rating from at least one CRA registered with IFSCA or any foreign jurisdiction. So now these are very important things to note that from 1st April 2025, you would be required to have a credit rating from at least one credit agency registered with IFSCA and in any foreign jurisdiction. Suppose if you are incorporated in a foreign jurisdiction and you are trying to list those debt securities here, then if your country, your foreign jurisdiction CRA will also work. The public issue, the issuer shall comply with requirements such as appointment of trustee, creation of debenture, redemption reserve, and all those things. These are standards. So disclosure in offer document. So what are the main disclosures? I mean, globally it is the same. If you see disclosures in global offer document, these are the standards globally, and because IFSC is benchmarking global standards, and you will find the same offer document, same thing which you find anywhere in the world. The issuer shall provide material policy if applicable and ensure the disclosure of all the following material disclosures are mentioned in the offer document. Now you can see it's a detailed offer document summary, risk factor, general information, capital structure, underwriting, tax implication. It's a very, yeah. So declaration as specified by authority, or if IFSCA gives certain additional requirement, then they have to be disclosed, and audited financial information of the issuer for at least 3 years shall be disclosed. If the issuer has been in existence for less than a year, the financial information provided shall be audited. So it's like that. So friends, now we can see the process of listing. This is a broad process of listing which I have just mentioned. How you go about it may be here and there, something may be simultaneously, something may be first or second, but this is a broad process for listing in IFSCA. So you appoint a lead manager and compliance officer. From my side, whoever is doing pehle law firm appoint kar lo. India Juris is there in Gift City. Just kidding on that. So the process start, appointment of lead manager and compliance officer. You file an application with the stock exchanges. We have 2 in Gift City at the moment, you all know. Seek their in principle approval. So lead manager shall submit draft of offer document along with due diligence certificate. Kisko submit karega? IFSC ko regulator. The draft offer document shall be hosted on the website of the authority. As you see with SEBI also, you have all RHP are filed with SEBI. So similarly, on the website of authority, recognized stock exchange, issuer and lead manager. So these offer documents will come there. The authority may issue observation, if any, within 21 working days, which shall be incorporated in offer document. So friends, one thing I would like to say, the regulator in Gift City is very proactive. If it is written 21, so I'm sure you will get reply within 21 days, maybe earlier than that. So as far as speed is concerned, cooperation is concerned, I can assure you will get a next level experience on that. Then the issuer in consultation with lead manager will determine pricing through either a fixed price or a book building process. IPO shall be open for 1 to 10 working days. The issuer through lead manager shall file a post-issue report. So now there is a provision of post-issue report with stock exchange within 10 working days from the date of closing of the issue. The issue shall make the offer within 12 months from the date of issuance of the observation by the authority. So we just read, took that it has to be within 12 months. The authority may issue observation, if any, within 20 months. So this is the broad process of listing of all the securities which we just saw, whether it is specified security, it is debt security, or it is a depository receipt, or it is commercial paper, whatever you are going to list. So this is the broad process for that. Then post-issue report. The issuer through lead manager shall file post-issue report. This is after the issue. This is the one of the compliance. Shall file a post-issue report with the recognized stock exchange within 10 working days from the date of closing of the issue, indicating the following. So all these things he has to file the report with the stock exchange, which is India BSE and this international stock exchange for NSE. So number value of the percentage of all application received, allotment made, basis of allotment, subscription, detail of credit, detail relating to payments and refunds, and the date of filing. So friends, now we are on this was all about for today about the presentation on this particular aspect of listing in GIFT City. And I hope in this regulation, you would see that a whole international attempt has been done to get the international investors here, give them, whether it's an Indian company or a foreign company, they can have better access to Indian market, to global market. And a level of ease has been created. And I'm sure in coming days, the professionals who are here or in the country who must be reviewing these guidelines, they will definitely find and advise their clients or their connects about the existence of these regulations so that they can take benefit of this. And I'm sure that these things would definitely take India to a different level when large number of aspect transactions are happening in India. And we are very positively looking at. And as I said in the initial, that at the moment we are some assignments are underway. After 1 or 2, 3 months, we would have a practical exposure on these guidelines, and we will be sharing our practical exposure and practical aspects in other webinars down the line. So Toshika, we can this is all from my side. We can over to you. Thank you.
Thank you so much, Mr. Samir Rastogi, for this interactive and information presentation. Through this presentation, we have gained some clarity over the listing of securities. While the discussion was underway by the speakers, we received various questions from our participants as well as offline questions at the time of registration. Let's move forward with the questions. First question is for Mr. Samir, sir. Who are the participants required for the listing?
Can you just can you just please repeat the question?
Who are the participants required for the listing in IFSCA?
Participants means I think you are talking about the stakeholders who are involved in the process of the listing. So it is like you can include all the people who you will touch upon, like your stock exchange, your depository, your investment bankers, your clearinghouse, or your you can call debenture trustee. So all these would be, you will be involving while you are listing. Nonetheless, law firm को भी आप लोग involve कर लेना. Okay. Yes.
The next question is to Mr. Shivram sir. Whether unlisted company intending to list on recognized stock exchange and IFSC are also required to list on domestic stock exchanges.
I'm sorry, Tosha, can you repeat the question again?
The question is whether unlisted companies intending to list on recognized stock exchange and IFSCAs are also required to list on domestic exchanges.
No, they are not. They are not. They are not.
All right. So the next question is to you, Shivram sir. What are the advantages of listing without public offer?
So if you ask my personal opinion, what you get is a better access to the international market. You have a better access to excessive capital. You get an exposure towards the international branding of your own company. The third aspect, which I would say, is diversification, where you will find a low cost, I would say, to get your fundraise. But that should not be the sole intent where you should consider. You should be targeting which exchange you are following or which country you have your customers or your clients. And according to that strategy kind of a thing, you can take a leverage and make a diversification.
All right, sir. The next question is to Mr. Sameer, sir. Which companies are not eligible to raise capital under listing regulations?
See, when you say which are unable to raise capital, which are basically like you are Section 8 company, which are NGOs, which are registered as or Nithi companies, or you have the companies which have defaulted, or the companies which are non-compliant, or companies which have winding up going on. So such kind of companies would not be able to raise. I mean, it's a general globally, nothing is specific on that, but such companies will not be able to raise any kind of fund and would not take benefit of these guidelines. They cannot raise funds through GIFT City.
My next question is to Mr. Shivram sir. Under what circumstances can a recognized stock exchange relax the applicability of certain listing requirements?
So I think Regulation 129 states that if you have any sovereign fund or you have any exemption from any other regulator, and also if you have a supernatural or something like that. So there's, I think in section Regulation 129, it says that yes, a recognized stock exchange can give you an exemption.
All right. My next question is to Mr. Sameer. Eligibility criteria for qualified institutional placements.
See, the requirement with the issuer must be a public company with equity shares listed in India. So there should be a compliance with IFSCA rule and stock exchanges and necessary disclosures and filings. So if you see whatever we have seen so far in all the listing procedure, whether it is for a specified security, whether it is for depository receipt or for a debt security, these things are everywhere, that you have to comply with IFSCA law, that you have to make disclosures, and these things are specific, are also required. But here one is it, the issuer must be a public company, Indian public company. So that is one of the requirement, and thereafter you have standard things. Yes.
All right, sir. My next question is to Mr. Shivram sir. What happens if no business combination occurs within 36 months in SPAC?
So if you don't, if the combination doesn't happen, then the sponsor commitment will have to be refunded. And this will happen through an escrow account where you will have to make the payment and the SPAC will get delisted.
So basically, as I told Toshika, SPAC is basically a special purpose vehicle which is formed for a particular particular, for example, you have like say the SPAC is made for acquisition in, let us say, hotel industry, for example. So once the things is done and within 36 months, if you are not able to spot the acquisition target, what you are going to take, then what you do, then it has to be delisted again and the money has to be returned. It's that way.
All right, sir. The next question is over to Mr. Samir, sir. What is the delisting process under the listing regulations?
See, delisting, for, as I said, we just saw about SPAC. So you have to file an application with the stock exchange if you want to get delisted. Review and approval by the stock exchange and notification to the shareholder investors about delisting decision. So this is a very broad general you will find in global benchmark processes. This is a globally benchmark process where you will find everywhere the situation would be the same. If you go, whether you go to Hong Kong or US, you'll find the similar way of delisting of the security. So the same has been benchmark here in GIFT City.
Thank you so much, Mr. Rastogi and Mr. Shivram, sir, for enlightening the participants. And I would like to also thank all the participants who spared their precious time and listened to the speakers. I hope they have resolved their queries as well as gained some clarity on the practical aspects of setting up funds in GIFT City, their structuring as well as their taxation. It was wonderful wonderful presentation by both our speakers as well as and we are also enlightened and had our queries and practical issues resolved revolving around the listing of securities in GIFT City. Thank you so much for your presence in time.
So thank you all of you. And I think, as I said, please get connected for the practical. In this regulation, our discussion was revolved around the regulation which is provided in the regulations. And but 1 or 2, 3 months down the line, we promise to bring upon the practical intelligence. What are the hiccups, what are the problems, what one should do, one should not do, and what is more taken up in the market. All these practical intelligence, when we are doing these matters, we'll be bringing to all of our audience. So stay connected with our next webinars. Thank you very much. Thank you all of you.